Hi, and welcome to Divorce Hacker. I'm your host, Ann Grant. On this show, we'll have a variety of guests who've been through divorce and are experts on the topic. Whether you're thinking about a divorce, in the midst of it, or already divorced, we are here to share our stories with you in the hope that you may relate, learn, process, and overcome whatever you're experiencing in your life. Since 2013, Sarah has exclusively practiced family law across California, representing clients from case inception through trial. A skilled litigator who prioritizes efficient, strategic resolutions, she handles custody, support, move-away cases, and complex asset issues with care. Sarah also advises on prenups, postnups, and cohabitation agreements. As a child of refugees and a co-parent herself, she brings empathy, cultural awareness, and fierce advocacy to every case, treating her clients' matters as if they were her own. We are very excited to welcome Sarah on the Divorce Hacker today. Sarah, you've been practicing family law for over a decade. What brought you to the practice of family law?
So at a very young age, being an advocate came very naturally to me, as my parents are refugees of the Vietnam War. So it was always like, read this for us, call this person. And also, I am the eldest of three children. So I was always I would say, the second parent to my siblings and also, a representative for my parents. So going into law school, I always wanted to I had I envisioned working for the people, being in the trenches with clients, navigating them through their legal woes and seeing direct impact to a client's life. So I was like, okay, where can I make a direct impact? And I thought being a district attorney. And so for my summers in law school, all my summers, I was conducting preliminary hearings, minor felony cases. I was working in the misdemeanor department. But then I very quickly realized that that was not the place for me. I just wanted that client interaction, that client contact. So, I was like, okay, well, maybe I will do some general counsel work because I had the opportunity at the time. So I worked for a nonprofit. It was telemedicine in Nigeria. That was, the foundation of their work, their cause, their mission. And I'm sure I made a direct impact in some form, but again, I wasn't in the trenches with clients. So, I had to reflect and think, where can I make a direct impact? I was really unsure at that point in time. I had just passed the state bar. And at the same time, in my personal life, I had just had my first child, my daughter. And unfortunately, my relationship with her father, my ex, it wasn't working out, to say the least. And so I was stuck in this limbo where I'm like, I'm a new attorney. I'm also a new mom struggling with, all the things that come with being a first-time mom. So at that time, I had a support group, single mommy support group that I went to, which I think we can talk about this a little later, but it's so important, um, in terms of, mental health and all of that, but we can get there later. So I had this support group that I was going to, and one of the moms, and I know you have a similar trajectory to family law, as I do. One of the moms at that time, she came to me and she was in a very contentious divorce. And she asked, would you be able to represent me? And I'm a very transparent person. I'm very frank. And I was like, you know what? That's not my area of expertise. I'm not comfortable with that. And she's like, no, talking to you, I know you can do it. I really believe in you. And she just felt really out litigated as well. Her husband's attorney was, I guess we can consider him as one of the legal giants in the family law um, arena, as we'll say. And she just felt like she didn't have her day in court. She didn't feel like she was being, properly advocated for. So I said, okay, well, we can try this out. And I did, and we had many wins. Um, and they were all custody related wins. And I saw the direct impact on her child, who happened to be friends with my child. And, her child was also a special needs child. So that was a high for me, seeing what the result that I got for her, how that affected her child, how her child's life changed. And, the referrals came in after that. And I was like, that's it. Family law is for me. So that's how I got into family law. Yeah.
Now,
It's been a wild ride.
it is a
Yes.
wild ride.
Yes.
So you're co-parenting your daughter with your ex.
Mhm.
What have you learned about co-parenting through your own experience that you now use in the work with your clients?
Yes. So, very early on, after our separation, my ex and I went to co-parenting therapy, and I recommend this to all clients that have a contentious, um, you know, relationship, and whether there's a child involved. It does wonders. I mean, if you're an individual that's willing to be receptive to that, I mean, it will change the whole dynamic. It has the possibility to change the whole dynamic of your relationship with the other parent, and obviously the child, like the trajectory of the child's life. So going back to my experience with my ex, we went to co-parenting therapy with a very notable therapist, someone that the court regularly used, as a recommendation to parties that go to this co-parenting therapist. We went, and this therapist said something during one of our sessions that really resonated with me. She said, treat your child like a business, and that you went into business with this business partner, your ex, and your relationship with that business partner has failed. There's been a breakdown, but the two of you share one common goal, and that is the success of that business, right? And success being defined by your child's mental, emotional, and physical well-being. And as a parent, obviously you love your child. You want the best for your child. And if it really is about your child, you will want the best for your child, and you will put everything aside, for your child. And for me, I love all my children. I have three now, with every fiber of my being. So whatever animosity, resentments, and other negative feelings that I had for my ex, they just dissipated when I heard that. I was just like, that has so much that resonated with me on such a deep level. And I tell clients that all the time. I'm like, if this is really about your child, you have to be reflective. You have to be introspective. And if this is really about your child, I tell my clients, then you will do everything and anything to ensure your child's well-being. And so I tell my clients this all the time, you know.
That's wonderful
Yeah.
advice. What communication skills are helpful when you're dealing with a problematic ex and
Yeah.
you are trying to co-parent?
Yeah. So before I give my three S's, I call them short, sweet, simple, um, I have to give some context. So whenever I have a custody issue that I'm dealing with for a client, on behalf of a client, I always tell them, getting getting your custody goals for you involves you playing a game. And I hate to say that because it sounds very cold, Because I mean, at the heart of this is there are children and people involved, right? And I say, in order to play the game, you need to play by the rules. And the rules are that when you communicate with your problematic ex, you need to keep it short, simple, sweet, because you have to keep in mind that every communication, written communication that you have with your ex will be under the microscope. It will be viewed by the courts. And if you're trying to, for example, gain legal custody because you think it's in the best interest of your child, because you can't, for instance, make a decision without the other parent obstructing, your ability to make the decision for your child. The court, if you're not keeping it short, simple, sweet, the court is just going to be inundated with all these communications, and they're just going to throw their hands up in the air and say, okay, this is just two parents that are bickering, and you're not going to get what your custody goal is. And so, I mean, I say short, simple, sweet. Obviously, sweet. I'm not saying be saccharine. If every parent has, or every client has, their own dynamic with their ex. So sweet meaning civil. Keep it civil. Don't engage. And I mean, this has benefits threefold. Number one, you are communicating to your ex that you have boundaries and you're not going to engage. And when you do that, you will see a difference. You will see that that other parent, I mean, they know that they're not going to get a reaction out of you. So they're going to quit. They're going to forget about it. They're going to be like, okay, this other parent has communicated that anything that I do won't press their buttons. It's not going to work anymore. So you should see a substantial decrease in that other parent provoking you. Secondly, you're going to very quickly, it's going to become very second nature to you. And you're going to see that, I mean, obviously there are relationships where you have another party that may have mental health issues. You may be dealing with a narcissistic person. But you're going to see that, if you're going to continue to do short, sweet, and simple, it's going to become second nature. And you're going to get to a place where you're going to start to accommodate each other. You're going to say, our child Sally is sick. Can I keep her with me for a little bit so that, I'm not exposing her to anyone in your household, or it's, I'm working late. Can you pick up Sally for me? You're going to get to that point. And third, obviously, what we just spoke about is, if you have a certain custody goal in mind, if you stop all that bickering back and forth, the court is going to have a much easier time giving you what you want. Let the other party's actions speak for themselves. Yeah.
That's excellent advice. And I know that we work with clients
Yeah.
together where you've coached them on this, and we see the benefits of it almost immediately. What is the biggest mistake that you see divorcing or separating parents make?
There are so many pitfalls, Anne, but I feel like the crux of a lot of these pitfalls comes from not giving yourself the space and the grace to properly grieve. And when I say that, I mean that we obviously, getting into relationships, having children, we envision a certain life, right? And when it doesn't go to plan, we're left scrambling, we're left in our thoughts, we're left with a lot of negative feelings of resentment, jealousy, rage. And if we don't properly deal with those emotions by seeking, for example, mental health, which is what I spoke about earlier, those feelings will manifest and obviously come across, I guess I should say, in the communications with the other parent or your ex, the other party. So first, you need to give yourself the space. Seek out mental health resources if you can, if feasible. And from there, if you take care of your mental health, I think everything will come along. But some of the pitfalls I see, specifically and related to custody, are dictating how the other parent should parent the shared child during the other parent's custodial time. Obviously, if the other parent has, issues that we should be concerned about, like substance abuse or other, factors that may impinge on their ability to parent the child, that should be brought to the court's attention through a motion and whatnot. And they probably wouldn't be having the custody time that they do have. But you should, if you're sharing a child, in a, equitable manner, 50-50 and whatnot, you should trust that the other parent knows what they're doing in terms of parenting. One question I usually tell my client to ask themselves is, you know, if you guys were married, would you trust the other parent to do X, Y, and Z? And often the answer is yes. So why do you not trust them to do that now that you guys are separated or divorced? So yeah, that's a very common pitfall that I see, is trying to dictate what the other parent does. And, I'll often see in communications that my clients give to me, when we're preparing for a motion per se, the text, or talking parents or OFW communication will say, you should be doing X, Y, and Z. And I have to tell my clients, no, you need to cut that out. And, just to give them an example in my personal life, I don't like sleepovers. That's something that I think that a child should be of a certain age to do sleepovers. Obviously, everyone has their own levels of trust and whatnot. So, my ex loves to do sleepovers, likes to coordinate sleepovers between our daughter and, her cousins or, close friends. And at first, that was something that I was really bothered by. But then I asked myself, do I trust the other parent? And I do. I trust that the other parent will keep our child safe and will do all the necessary things that they need to do to ensure our child's safety. So yeah, like I said, like all of this ties into being introspective at the end of the day, and seeking out, mental health resources, and examining why we react the way that we do.
That's really good
Yeah.
advice. I think, what you mentioned about wanting to control
Hmm.
what's happening
Yeah.
with the child in the other parent's household is something that we see a lot.
Yeah.
And I think it's very hard for parents and particularly mothers to let
Yes.
go
Hmm.
of that. And yet, your advice is really excellent
Yeah.
advice.
And oftentimes like I said, when we keep it short, sweet, and simple, we will get to that point. We can get to that point where we can express our feelings to our co-parent and say, hey, I'm not comfortable with this. Can we maybe, ease into this? For example, using sleepovers as a hypothetical. Can we maybe ease into this and set, boundaries that we can both follow in both of our households? So I think that, and oftentimes maybe you'll never get there because, like I said, the other parent may be dealing with, mental health issues, or they, personality disorders and whatnot that we see a lot in our practice. And in that case, you'll have to practice what we call parallel parenting. Like, you just do what's best in your household. Let the other parent do what's best, what, they see fit in their household, and just trust the process. And, if there's any issues that, you may be concerned about, that's something to discuss with your attorney.
And what are the kinds of issues that would arise concerning a child's health, safety, and welfare that would you think is appropriate for the client to call us
Hmm.
and get us involved in an effort to get more custody?
Yeah. Oh, that's a very fact-specific question. Are we talking about physical custody, legal custody, or?
Well, let me ask you this way. So, is it the norm these days for a court to order 50-50 legal and physical custody? And what are the instances where they might award sole physical custody to mom or dad?
Yeah, so oftentimes I get clients who will come and ask me, hey, Sarah, I've heard that, like, courts usually just order 50-50. They just order, joint custody. Is that true? And I like to say to clients that That's like a default setting. Let's think of that as a default setting. Courts are inclined to order joint custody. Obviously, if there are factors impinging on a parent's ability to parent a child, that's a different story. But as a as at a base level, the courts will usually order a joint custody. Um, well, in the along with the notion that it's in the best interests of a child, in the best interest of a child to have frequent and continuing contact with both parents, and for both parents to be involved in the nuances of the child's like daily life. Um, but however, having having the right attorney um, can very often make the difference in that result, because a court, obviously, having the best interest of the child may not be that both parents are involved equally in the child's life. It may be that one parent, because of, I mean, it could be as something as simple as the other parent has a very hectic work schedule and may not be able to dedicate as much time with a child as, for example, a parent has been historically the stay-at-home parent. So I say that at a base level, a court will award joint custody, but depending on very fact-specific facts that are individual to each case. Um, that may not be the best interest of the child, but it takes a very skilled attorney to make that argument to the court. So, yeah, I say that that's a default setting. Courts are very inclined to order joint custody, but that's not always in the best interest of the child. So, speak to your attorney about what the specific facts are of your situation, because oftentimes a court's determination will impinge upon those facts.
Yeah, and what I found too is that courts want to maintain the status quo
Exactly.
if it's working for the children.
Mhm.
And so when I have clients come in and they tell me that they want to be deemed the, custodial parent with the most time, then I will find out what is the current schedule?
Yeah.
How is it being handled? And certainly before you go to court, you want to be implementing whatever the schedule is that you would like to have to the extent possible.
Yeah.
Because unless the child's health, safety, and welfare is at risk, they're likely to maintain the status quo
Yeah.
with the goal of these days working up to a 50-50 schedule if it makes sense,
Mhm.
given the geographic location of both parents, if they're living separately, the demands of their work schedule, and all things considered. But the best interest analysis, which you've mentioned several times, is a very subjective analysis. And so when we get into that, we're looking at a number of things. We're looking at where the kids are going to school, how they're doing in school, who the parent is that is preparing breakfasts and lunches and dinners and
Mhm.
putting them to bed, who's getting them to their extracurriculars, and so on and so forth. But even during the time I practiced family law, I've seen a shift because I think it's a function of most couples are
Mhm.
both working almost equally now.
Yeah.
And a lot of people now are able to work from home, work remotely. And so consequently, there's been a greater sharing of child responsibilities,
Yeah.
certainly than there was even when I went through my divorce. And I think that's being reflected in the orders that we're seeing being made.
Definitely. That's why I always say view it as a spectrum, and in the middle is joint custody. And, the standard is, like we said, best interest standard. And the courts, depending on the specific facts of a case, a court will deviate from what's, you know, the default setting, which is, 50-50 custody. And it depends on all those factors. So it takes a really good, skilled attorney to go in and, provide those facts to the court in eloquent fashion, and to let the court know that, like, hey, like, you know we get it. This is the best interest standard. The best interest standard is to have both parents involved, but given, what's historically gone on in the relationship between the parties, what the children are used to and accustomed to, work schedules, etc., the best interest of the child is really this, and it could be the status quo and whatnot. But oftentimes we'll see too, and the fact that after a party's divorce, um, a parent that has historically been a working parent will often try to accommodate their working schedule um, to fit the needs of that child, having in mind that they want to spend more time with the child. So sometimes, I mean, it's just a shifting, it's always a shift. The analysis shifts back and forth. So, like I said, it's very fact specific, but the general default setting is always it's in the best interest of a child to have time with both parents.
Right.
Yeah.
And since you and I both spend a lot of time in court, we understand that judges are interested in looking at the evidence.
Yeah.
So it's not helpful when they have two parents who are just bickering and
Yeah.
they're the best parent. And so I have found that in advising clients early on, I suggest to them to keep a log of what's going
Mhm.
on with their children if they're observing issues that are concerning to them when they're in the custody of the other parent and they would like more custodial time. And this serves a number of purposes. It creates a record, which we need when we go to court to establish the facts. And it also allows us as lawyers to ascertain whether the complaints that one parent has are sufficient and rise to the level of what a court would be interested in terms of making these custodial decisions. So, to your point earlier, when you were talking about trusting in the other parent to do things um, during their custodial time, if, for example, you're the mom and you don't like the lunches dad's packing, that's probably, when we see that in the records that they're keeping and providing to us, not going to rise to the level that a judge in LA Superior Court who's handling 15 to 20 cases a day, and sometimes there's serious child abuse, that's going to move the needle to where they're going to want to change the custodial schedule. But on the other hand, if there is neglect, or as you've mentioned a number of times, the other parent is engaging in substance abuse during their custodial time that's impacting their ability to show up properly for the children, those, of course, are things that need to be brought to a court's attention. And it may be in the child's best interest to spend more time with the other parent if they're in any sort of danger. So has that also been your experience?
Yeah, definitely. And that's why first thing I do when I ask a client who is facing custody issues and wants a particular custody arrangement, specifically primary or sole physical and legal custody, I ask why. And I want if the client can eloquently and provide me with legitimate reasons as to why it's in the best interest of the child that that parent have primary or sole legal or physical custody, then it's we're game to get the client what they want, because if they can't articulate why, and it's my impression is um that maybe it's like we discussed before, it's coming from a different place. It's coming from maybe, viewing that, themselves particularly as the better parent. We see that a lot. So, and I'm not, as an attorney, with experience with the judges in LA Superior Court, I am not going to appear in front of a judge and ask for something that I don't think a client will get, unless a client is telling me, hey, like, I really believe in this. Let's just go for it and see what we, where we land with the judge. I want my day in court. I want to feel vindicated. I want to feel, and oftentimes it is about that. It's about justice, and principles of justice for our client. But I'm very transparent with clients from day one. I'm like, what is it that you want in terms of custody, and why do you want it? And I think if clients can, articulate legitimate reasons for why they want what they want, um, then, we can go to court and we can get them that. Yeah.
Is there anything else that we didn't talk about today that you'd like to add with regard to co-parenting or any of these other issues that we've discussed?
Um, for me in particular, co-parenting with my ex, I feel like one of the things that I had to do was really silence the voices of others around me. Everybody will have an opinion as to how your co parenting relationship should go, as to what you should do in terms of parenting your child moving forward, as to what the other party, your ex, is doing or is not doing. But like I said, going back to the saying of your child, treat your child like your child's a business, and your ex like your business partner that you had a falling out with. Um, you've got to really silence those voices and really, again, introspection. Look inward and think about, okay, what do I think is in the best interest of the child, and what do I need to do to achieve that? And I come from a culture, and I'm not going to generalize, but I come from a culture where, divorce and separation, where there's a child involved, is frowned upon. You know, yeah, frowned upon. I was going to say taboo, but no, frowned upon. Um, and I had family members that would be like, "You should do X, Y, and Z. You shouldn't be speaking to the other parent. You guys are done. You guys are not in a relationship anymore." And oftentimes I would get friends, even friends, and family members speaking negatively about my co-parent. And whatever I felt about my co-parent, I had to just toss aside and say that is not helpful to my child, um, to be thinking these things, or to be reacting or acting hostile towards my co-parent. I just need to focus on the success of my child, their safety, health, safety, and well-being, and silence everyone else. And, it came to a point where I actually had to tell my close ones, hey, I'm not going to hear it. That's not in the best interest of my child. I don't want my child to also be exposed to, these types of communications. Children are like sponges, and, you have children yourself, so and your family and friends will come around. They're your family and friends for a reason. So that is something that in my personal life, I had to do. And I often tell clients, like, yeah, your friends and your family, they'll often tell you what to do, but you know best what to do. And you know what's in the best interest of your child. So
That's excellent
yeah.
advice. Thank you so much. I really appreciate you being here today with us.
Thank you so much, Anne.
Thanks, Sarah.
Thank you.